Hello, I'm Tim Larson. I'm a partner here at Larson & Brown. We're an estate planning and estate administration firm, and I'm going to be discussing with you the last article of our living trust document, which simply is titled General Provisions. In a joint trust, this is Article 16, and if you have an individual single grantor trust, it's going to be a number lower than 16, such as Article 13, but it will be the last article, and it's general provisions. There's certain things in here that we like to point out to clients so that you understand why this is here, because some of this can be very confusing. The first section says maximum term for trust. Well, why do we have to have that? Well, as the law has developed in Kansas and in every state, and as the law developed as it came to us in the common law from Great Britain, there was what was referred to as the rule against perpetuities. And what that law meant was that a trust can't be perpetual, it can't be forever, it's got to have an ending date. And as that law was developed, it was determined that a trust should not be controlling property longer than the lifetime of an identifiable beneficiary who's living at your death, plus after their death an additional 21 years. In law school they teach that as a life in being plus 21 years. It's still a very confusing concept, but also the way the law is developed, we have to have a provision in the trust document to show that we are not in violation of that. So that's why we have this section that says maximum term for trust, which verifies that no trust that's established under the trust document, for example, if we're going to have trusts for children or grandchildren, those trusts can't last so long that they would go beyond the lifetime of a beneficiary who's living at your death plus 21 years. And so we have to have that provision in here. Kansas has a statute that says that a trust can't last any longer than 90 years, and then it goes on to say, or if you have used a provision like this, if it turns out to be more than 90 years, that's okay, but you have to be able to tell from the document who the identifiable person should be at your death, so that we know whose lifetime we're following, and so their lifetime plus 21 years will be the end of when the trust could control anything. The next section is a spendthrift provision, and it's not very long, but it's really important and it's really significant, because in Kansas we have a statute that says if we have a spendthrift provision in a trust, that once the trust is in place for someone other than yourself or yourselves, that no creditor can reach in and touch anything that's in the trust. And that's very significant. It provides some incredible asset protection for children, and it's very important that it is in there. Would protect children from losing it to a creditor, because that language is ironclad if it's in there and enforceable under our law and statutes. There's also a contest provision. A no contest provision is usually important if beneficiaries are not receiving benefits in an equal fashion or in a fashion that they perceive that is not fair. And so in most cases where we're providing for children equally or that type of planning, there's no issue. But if there is, we often send a copy of this to whoever's raising some concern to make sure that they know that if they challenge or contest the trust, that they're to be treated as if they predeceased you and they don't get anything. Pretty harsh. And I sometimes refer to that as the drop dead clause, because you're telling them, if you challenge this, you're treated as if you died before we did, and you don't get anything. Just for interpretation purposes, we have a section that says survivorship presumption. If you're married, we typically put in your document that If there's a common accident or for some reason the order of death can't be determined, that in that event we're simply going to presume that each spouse predeceased the other and deal with how the assets would have to flow because of that interpretation. In addition to that, we have another survivorship presumption. We say if any beneficiary of the trust dies within 60 days of the death of whether it's you or the second spouse to die, if they would die within 60 days, that we're going to treat them as if they predeceased you and to distribute the property however we plan to have it distributed if that beneficiary is deceased. So we don't have to distribute it and have a probate estate for that deceased child or deceased beneficiary. And those are all on the first page of the article on general provisions. If you're married, there's a provision that addresses, it says effect of legal separation or dissolution of marriage. And I think the most important thing that we try to tell people is that if you've done an estate plan like this, and in the event there was a separation or divorce, it's not going to affect your right to property in some fashion in an adverse way. A court is still going to be able to determine how property should be divided and distributed. And typically in those situations there's usually an agreement, but sometimes there's not. Beyond that, we say that Kansas law controls. You'll see kind of a funny word where we say situs of administration. Situs for a trust is much like the residence of a person. It's where that trust basically exists and is being administered, and Kansas law would control. But if you want to change all of that, there are provisions in the law for you to do that. If you move away from Kansas, the trust should still be able to continue, and you can sign an amendment or document if you want the law of another state to control your trust. Other than that, the last section in general provisions is primarily definitions. They're very straightforward. I think you can look at that, and if you have any questions, it's pretty self-explanatory. And then after the definitions, there's a provision that just kind of talks about interpretations of the document, general provisions and rules of construction, so that it's clear that if it should have been plural and it was singular, that's okay. If it should have been masculine instead of feminine and gender, that's okay. Headings are not part of the text of the document and they don't control. And then it also talks about how if we need to give notice to a trustee that they're being appointed or removed, how that's to be done. And then finally a paragraph that you see in most agreements that says that if any provision in the trust is determined to be invalid, it doesn't invalidate the entire agreement, it just invalidates that paragraph or section. And that's it. That's general provisions relating to the trust. If you have more questions, you can call us at 316-729-0100 or take a look at our website, larsonbrown.law. And we're happy that you've chosen to do some planning with us, and again, that this information may be helpful. Thank you.